I also want to otherwise put this work, Mr. Chairman and colleagues, in context. We have received feedback, and I'm sure this committee has as well, from people who say, on one hand, that the bill goes too far, and those who say it does not go far enough. We've received feedback from those who, on the one hand, are extremely passionate about wanting their data protected, and those who question the very provisions of the bill that are specifically designed and drafted to protect people's data. And so I pause this legislation in order for it to come to committee, to encourage us as Barbadians to reflect on what we want. And I say that with all sincerity, to reflect on what we want and the kind of world we want to live in. And I feel quite heartened and I feel quite privileged that we have the kind of democracy and parliamentary system that allows us to do that. But I say that to suggest that we can determine that we want to fully experience and enjoy all the benefits of technology and living and working and having our being in an online environment, and then pretend that they're not risks and therefore safeguards that must attach. So I fully support the use and the work of bipartisan committees such as this one, Chair, because these matters of security and safety cannot be the subject of political opportunism. Our democracy must finally become more mature than that, and I've been very heartened to see some of the honest conversation that has been taking place. But I have to highlight that data and technology are the new global currency, and they are also at once the new global nuclear weapon. And I do not exaggerate. The scope for harm in the area of data and technology, where there are no borders, where action is often invisible, the scope must be taken in its full perspective. National security councils all over the world, including ours, now realize that they have to contend with this in a way perhaps more than they have to contend with matters of physical security. We have, in a matter of days now, Cricket World Cup starting here, where the world will be in this region and the world will be watching this region. And we have to make sure that we have the wherewithal to be able to respond and to protect our people, to protect our systems, to protect our information, because that information is the currency and equally the weapon that will be used by those who want to harm us. So I am glad that this committee in its bipartisan nature gives an opportunity to all sides to show true, evolved leadership by not deliberately mischaracterizing the intent and likely impact of the law, but by focusing honestly on people's real concerns, many of which are worthy of our reflection. And so again, I thank those people who have brought their concerns to this committee and to our attention. So, Mr. Chairman, I'm not going to attempt to repeat my hours of presentation, first on piloting the bill and then on wrapping up the debate in the House. You have those presentations in your evidence, and in those I speak to each clause and respond to many comments that have been placed at that time in the public domain. All I'm going to seek to do here this afternoon is to clarify a few questions that have come to our attention, to address some concerns, and finally to offer you some suggestions based on my own reflections on this legislation. So I want first to draw our attention to a global example that we've seen recently, and it is a case of Ruby Freeman, case out of the United States, and her daughter, Wandrea Moss. On November 3rd, 2020, Ms. Moss and her mother, Ruby Freeman, sat across from each other in a counting house, began counting the number of mail-in ballots that had come in during the US election due to the COVID-19 pandemic. At the end of that count, the tally showed that Joe Biden had a narrow lead over Trump, less than 15,000 votes across all of Georgia. 3 days later, officials in the state announced an automatic recount that would take place because of the thin margin, and Joe Biden at that time prevailed again. Donald Trump then demanded a second recount, which again affirmed Biden's victory. And in the meantime, Trump and some of his allies began sharing some unproven accusations of election workers allegedly perpetrating fraud. In early December, a month after Election Day, Ms. Moss learned that a video of her and her mother had been circulating online alongside what can only be characterized as outlandish interpretations of what the two women appeared to be doing as they were counting those mail-in ballots. Another video showed Ms. Freeman handing her daughter a small item that was imperceptible on the grainy live stream footage. However, some people online accused the two, these are regular election workers, accused the two of them of exchanging a USB drive, which was allegedly somehow meant to be used to manipulate votes. It turns out that the mother had in that case been passing her daughter some ginger mints. But the conspiracy theory, and I'm sure all of us know of this case, took hold and took off. The following week, the man who served as Trump's personal attorney, Rudy Giuliani, told legislators that a video circulating online showed, quote, Ruby Freeman and Shay Freeman Moss quite obviously surreptitiously passing around USB ports as if they're vials of heroin or cocaine, end quote. Facebook, on email, by phone, supporters of Trump who were disgruntled, convinced that Ms. Freeman and Ms. Moss had orchestrated an election fraud on a scale that was capable of upending the result of a nationwide election, began assaulting them with hateful messages, often with racist overtones. Shortly thereafter, their addresses were posted online. People started appearing in front of their homes, harassing them and their neighbors. Moss had been staying at her grandmother's home, and people also started going there. The result of this was that all of this, as one would expect, took a toll on these women's mental well-being. They had to give up their jobs. They had to move from their homes. They ceased going out in public. As a result of this suit that was brought against Rudy Giuliani and others, he was ordered to pay them $148 million in damages. And the matter has been elevated to criminal proceedings against Trump and others. Now, I start there to put in context the potential damage that we are talking about here. The fact that a video shared online, circulated online, followed by comments and harassment also shared online, destroyed the lives of these two women. And I dare say that what they have lost in terms of their reputation, in terms of their well-being, cannot be recovered, even with $148 million if they were in fact to see any part of that settlement. But I make the point that it was elevated to a criminal matter because I think that in these things, and this is what the legislation tries to bear out, in these things there is a very, very thin line between the civil and the criminal. And it is our estimation, and it is the experience of many people, that these matters begin to trespass, and in fact trespass wholly, in the area of criminal harm, injury, and damage. I also want, though, to put it in further context by addressing addressing the notion, I should say, that anyone who has anything to say in any circumstance that may cause a nuisance or irritation or that we might not like is liable to criminal proceedings under this legislation. I want to highlight, and I only repeat because I have done so in bringing the bill to the House. I believe others have done so. But the use of the word intentionally in the legislation is perhaps one of the most important things that we have to acknowledge. There must be intentionality behind the act in order for it to stand up to the kind of prosecution that the bill contemplates. There's also a certain evidentiary standard on the part of the prosecution that there are more lawyers in here than I've been around in a small room in a long time. So I don't need to tell you that the evidentiary standard is very high. The evidentiary standard that the prosecutor must meet is not just the balance of probabilities. It has to be beyond a reasonable doubt. The defense, the standard for the defense is then the balance of probabilities. And so I start there because, and I'll come back to it later in my presentation, because I want from the outset to dispel the notion that anything that anybody says, no matter the circumstance, no matter the intent, is the subject or is the target of this legislation. That's not the case. I'm sure that everyone in this room has read this bill over and over and over and understand that there must be intentionality. One must seek and one must intend to do harm, or one must intend to act without thought to the falsehood of the allegations being made. And I'll come to that a little bit later. I want very quickly, though, to go through just a few of the comments that have been made in the public domain. Some of the claims, I suppose, I would say, that have been made with respect to the Budapest Convention, the extent to which it has a certain amount of level of rigor, the extent to which it is, whether or not it stands the test of robustness as the convention that we should follow with respect to cybercrime. And so I just want to share a few things with you and with those who might be listening. There has been this claim made that the Budapest Convention, on which this legislation is styled or framed, is not best in class. The notion that there's a new UN treaty on cybercrime coming and that this legislation and the Budapest Convention are at odds with or incompatible with that UN treaty. That is not the case. And I will tell you for reference that I've had many conversations and consultations, not just with those colleagues from the Council of Europe who work on the Budapest Convention, but also people who are working currently on the UN treaty and who have a perspective on the comparative robustness of the two pieces of work. And I will not venture an opinion myself, but the fact is, and it has been documented, that there's no incompatibility at all. The UN treaty is not even complete. It is projected that it will be finished early August. The UN treaty is likely to be slightly more limited in scope, and in fact, some member states have already expressed concern that it is too limited in scope in many ways. There has been a claim made that the UN treaty will be more robust and more expansive. In fact, the opposite is the case. Nothing in the second protocol to the Budapest Convention will be reflected in the UN treaty. And in fact, the treaty copies the illegal access provisions from the Budapest Convention. And so the treaty in many ways looks to the Budapest Convention for guidance on how it should frame itself. You would be interested to note that since the beginning of the UN treaty discussions, the pace of countries joining and signing on to the Budapest Convention has been, in fact, picking up rapidly. So far from countries feeling as if they should step aside and wait for the UN treaty that is going to be more robust. In fact, countries have, since negotiations started on that treaty, begun signing up, becoming signatory to the Budapest Convention more rapidly. Under the Budapest Convention, you have over 70 countries that are required by law to be your friend, that are required by law to assist in cybercrime matters, and that cannot be understated. I'll say for the information of the committee that Grenada recently joined the Budapest Convention. Over the last month, 3 more countries have signed on, and 5 more are expected to sign on before the end of June. So there are now 73 party signatory and 19 that have been invited. And invited simply means that these countries have sent a letter requesting to join, and on that basis have been invited. I also want to highlight something. For those who say that the bill or the convention don't cover this or don't cover that or don't cover another thing. The fact that some things might be missing from the current convention does not put them out of the question. That's why protocols are added often to these kinds of frameworks. The second additional protocol is just that. It gives additionality. It doesn't amend what was there, but it gives additionality. It gives more options. And so this is something that I wanted to make clear because I think we need to be able to put to bed once and for all. We need to be able to clarify that, first of all, cybercrime legislation and the things that present are evolving. And that's one of the reasons there's some things that are noted that will be amended or changed in the schedule by ministerial order, because we fully expect that, you know, weeks, months, years from now, the technology that we'll have to be concerned about will have changed drastically. So that addresses the issue of compatibility with the UN treaty and this notion that the UN treaty is somehow superior. In fact, it is not. It is more limited, and countries, notwithstanding that it is coming by August, remain committed to signing up to the Budapest Convention. I also need to turn quickly to this question of ethical hacking. And it has come up with respect to the claim is being made that the bill should make provisions for this thing that is being loosely framed as something called ethical hacking. And I think that we have to be careful about how we define these things. So I will say, and we are aware, that there's some discussion in various countries of finding a way to permit different kinds of access for a public service purpose. In every country that I'm aware of, that remains unresolved. And why? It remains unresolved because it is very hard to distinguish this activity from a crime. And so one thing that the law must be is certain. And so, and let me explain for those who may not have been previously aware of what I'm talking about. There is those who have made certain inputs to this conversation have suggested that this practice of ethical hacking is something that is desirable in our jurisdictions. And what they mean by ethical hacking is that someone gains unauthorized access to your data or to your systems for the purpose of proving vulnerabilities. Unauthorized access. Now, in a situation like that, the first thing is to understand that the fact that the access is unauthorized means that this person is gaining access and is able to look at, review, save, disseminate data that the state has a responsibility to protect. The question is, when an individual gains unauthorized access, who is to say what they've been looking at? Who is to be able to control what they have access to? And the very responsibility of the state to provide citizens individual data becomes compromised. Now, I want us to understand that there's a difference between this and what has been commonly known to come to be called as bug bounty programs. These bug bounty programs, large corporations have been a part of. They've launched these programs, companies like Microsoft and others, Yahoo and others have launched these programs, inviting people to access their systems and show vulnerabilities. And really it's a way of, and they reward them. They say, I'm gonna give you access, you try to break this thing. You try to show where the vulnerabilities are. But again, in cases like that, the fact that it is a structured program with constraints takes you out of the realm of criminality. I have said this before. The government of Barbados, like most other jurisdictions, cannot contemplate a reality in which we allow unauthorized access. That would make any legislation to protect systems and data moot and irrelevant. So I wanted to clarify that and also to give the assurance that the notion that there's this widespread ethical hacking that countries have allowed, private corporations can do what they want. Private corporations can let ethical hackers run all through their information. They will have to answer to the regulations of that state. But as a government, we would be negligent in our responsibility to the people of Barbados to allow unauthorized access wherein a person gains access to our systems and our data and your data and then says, well, I'll show you how to fix this, or I'll give you back your information if you pay me a sum of money or if you let people know that I was the one who broke it. I do not see how, in a context in which we are trying to maintain order and people's privacy and people's security, we can allow that to happen. And just to reiterate that this notion that countries all over the world are doing it is incorrect. There was as well a comment related to critical infrastructure and that critical infrastructure systems should be listed in the legislation. I do believe that the systems that are contemplated with respect to Clause 12 are itemized in some measure in the schedule, and critical infrastructure systems are all represented except for those related to hospitality. A colleague of mine did raise this notion and whether, as a tourism-dependent economy, critical infrastructure that is related to hospitality might be itemized and included. And of course, specifying the nature of the critical infrastructure is something that one cannot object to. I mean, if the reason that it is able to be amended by ministerial order is that we expect that the identification of the critical infrastructure will change. We will set up more different kinds of critical infrastructure. We're talking about things like hospitals, cell towers, and so on, and that will change. There's also the question that came up of, and so let me clarify that it is itemized, it is specified, but also that we can't consider this an exhaustive list because infrastructure itself, technology infrastructure, telecommunications infrastructure, by its very nature, is changing. And there's infrastructure that will exist next year that doesn't exist now. And so that can be amended at such time as is necessary. There are those who have also raised the question of placing a positive obligation on persons or companies who are in control of critical infrastructure and systems to put certain measures in place. And actually that is also contemplated under the convention. It is also capable of being included in other aspects of law. And it is the idea that if you are a telecommunications company, a private utility, you have a responsibility to secure the infrastructure that services the people of the country. And there can be no objection to that. I don't know to what extent you, in making your recommendations for any amendments, may want to consider that, but it is contemplated under the convention, and it is capable of being introduced in other areas of law as well. I also want to respond to a comment on clause 21 that relates to cyber terrorism, and there is a notion that the provision for cyber terrorism is not sufficiently broad, which is a bit of a surprising observation, because it doesn't include solicitation or what the commenter calls preparatory acts. Let me say this. A thing does not have to have a particular label, I would say, in order to reach a level of criminality. So the guidance, not on the Budapest Convention on Terrorism, criminalizes, by the very definition of terrorism, the preparatory acts that are involved. And there are lots of jurisdictions that have separate terrorism legislation and in fact have not included this provision at all in their legislation. So I say that to say that I wouldn't be too concerned that we miss or we are unable to prosecute an act of cyber terrorism because we don't explicitly use the language preparatory acts, but that is contemplated in our definitions of what constitutes terrorism. Now, to come to part 3, which relates to investigation and enforcement. Again, there was a concern raised, and I think that it may reflect a less than thorough understanding of what these clauses relate to. Now, there was a concern raised that these clauses 26 to 28, but in particular clause 26, allows the state to intercept data in real time. Under this provision, the state cannot intercept data in real time. We deliberately did not include it in our own legislation, even though other countries who have worked with the Council of Europe and who are signatory to the convention have done so. And we did it specifically because we thought that it might trespass too far with respect to persons' liberties. This relates only to the production of data that is specified. So under this clause, you are saying exactly what you're asking for to be produced. And in fact, this provision is widely considered to be so non-intrusive. It actually proves to be perhaps the least problematic provision for most cooperating jurisdictions, because it relates to just the production of data that you say, that you specify that you're requesting. This clause does not allow, nor does it elsewhere in the bill allow the interception of data in real time. I have to say too that the search and seizure provisions under this legislation are fully in keeping, not just with what currently obtains, with all other legislation in Barbados. But the Council of Europe is doing a study of how countries authorize search and seizure under cybercrime legislation, and have found that 95% operate on the system of sworn affidavits and the system that is outlined in this legislation. That is the system that is used. And so I wanted to clarify that the search and seizure provisions under this legislation are not at odds either with what is currently done, to be able to obtain a warrant, to be able to have sworn affidavits and so on, for access to certain kinds of information in other kinds of crimes. But it is also in keeping with what the over 73 countries that are signatory also have as their provisions. Now, I also want to clarify something with respect to clause 27 and 28 on data preservation. To say that, and perhaps I should reference exactly what was the difficulty. So, data preservation is exactly as it sounds. It relates to keeping information exactly as it was, as it exists at a certain time. It does not relate to, and so the comment, let me just make reference to the objection that was raised. The observation that was made on clause 28. Clause 28 relates to the preservation of data for criminal proceedings. So what that means is that there's information that you want to be able to further review, analyze, prosecute. You want to be able to have access to it in the form in which it existed at the time. And the Commissioner of Police or any other officer designated by him in writing may make an ex parte application for a preservation order to a judge or a magistrate where computer data, including traffic data, stored in a computer system is required for the purposes of a criminal investigation, and B, there are grounds to believe that the computer data stored in a computer system is particularly vulnerable to loss or modification. There are grounds to believe that the computer data is particularly vulnerable to loss or modification. And the comment is that in the legislation, there's no discussion of the conditions and safeguards for adequate protection of liberties when collecting and storing data in criminal proceedings, including chain of custody. Chain of custody does not enter here because nothing is moving. There's no chain. All this is saying is if, for example, there's data that is likely to be the subject of criminal proceeding and it is being held in the systems of a telecommunications company, is being held on Dr. Springer's computer, is being held on somebody's flash drive. All I'm asking for is that the data not be destroyed. That's all. So for example, there's some companies or businesses that may have a system of automatically getting rid of certain stored data. So by asking that the data be preserved, I'm saying, look, don't get rid of this. I'm stopping you from getting rid of it. I'm not taking it anywhere. And in fact, data preservation is usually a fundamental first step. So what happens is you ask for the data to be preserved so that you can go and get a warrant to be able to further examine the data. The truth is that our level of authorization simply to keep data in place is a higher level of authorization than there is for most countries. In fact, most countries ask for the data to preserve to give them time to get a warrant. Here we are asking for a warrant to preserve the data, which is actually an extremely cautious approach to the matter of data preservation. In fact, From our review in 40 years of data preservation in the US, these days one doesn't even have to be a lawyer to make a preservation request. It is simply asking, and this is in that legislation, not in ours, it is simply asking that data not be destroyed. It freezes the data in the hands of the provider. It doesn't freeze the data in the hands of the government. That is flatly wrong, that suggestion. All it is failing to destroy, and there are no chain of custody considerations because the data has not moved. As an overall comment, I just want to say on the matter of search and seizure that police officers in this legislation, as with all other legislation, must act within the parameters of the existing warrant. And that is true whether it is a cybercrime or whether it is a physical crime. So I want to address the notion that somehow the fact of this being cybercrime means that all of a sudden officers of the law are at liberty or can take all kinds of liberties with people's own privacy and so on. Whatever would obtain in a warrant where you are the target of an investigation, I have a warrant that entitles me to go into your home, to go under your bed, to go into your pig pen, to go into your garage. Whatever is contemplated, whatever is outlined in the warrant is all an officer can have access to. Now, I want to come now, after those clarifications, to perhaps the part of my presentation that you may find most interesting. I hope that you find it interesting. And it is to say this. Notwithstanding that, clearly I believe that this legislation is necessary. It was deemed necessary as far back as 2005 with the Computer Misuse Act. There are other pieces of legislation that address these matters in other ways. As the law stood prior to the drafting of the cybercrime bill, the crime of criminal libel was a part of the law of Barbados. And most of you in here would know about Section 34 of the Defamation Act. In that same section, the defenses applicable to civil defamation were made to also apply to criminal libel. The idea of criminal libel is not new. It is being brought into this legislation from a place where it already existed. When the cybercrime bill was drafted, criminal libel was specifically abolished, and you'll note that in the schedule to the bill. But we realize that some defamations can be extremely egregious and can be so much so that they go beyond compensation for civil defamation. And I made this point earlier in my presentation of the bill in the House. We also have to consider that bringing a civil case against a person requires resources. It requires resources, and we have to be, as a state, we have to put ourselves in a position to be able to defend all people. Those two women in the US, if they had not had the full might of the opposing party and the outrage of other citizens behind them, they would have just been another story of two people whose lives had been destroyed by defamation or by criminal libel, or by libel. And so I want us to understand that the law has to be made for all people, and it has to protect all people. And simply preserving this area of legislation in the domain of the civil does not do that. Many of us speak every day to Barbadians who feel aggrieved by something for which they can't pursue litigation or take any civil action because they simply don't have the resources. And so I think it's important for us to understand that raising this or bringing this to the criminal space, first of all, is not new, because criminal libel existed before, and also is important to be able to protect people, but further, the scale of the damage and injury can be so great that in my estimation and the estimation of many other countries, it elevates it to the realm of the criminal. The other thing to note, and I'm sure that you've had this discussion among yourselves before, Clause 19.3 of the Cybercrime Bill, which I'll spend a little time on, purported to create a replacement for criminal libel, but sought, in its framing, to protect freedom of speech by giving a person the right to put forward any of the defenses mentioned in Clause 19.5. And I want us to be clear that these defenses matter and that we should turn our attention and the attention of the public to these defenses under 19.5. If a person is charged under 19.3 and can prove that he was speaking the truth, he will have, as we all know, a cast iron defense. And so truth as the ultimate defense is one that I don't want us to lose sight of, because I don't want us to alarm individuals with the notion that these provisions go against freedom of speech. In fact, they aim to protect freedom of speech in the context of criminal libel by the defenses that you've reviewed and that the bill lists at 19.5. As I've mentioned before, the essence of the offense in section 19.3 is the intentional use of a computer to disseminate information that is false. And so I reiterate the intentionality that must obtain, as well as the falsehood. But I will also say this. I have myself reflected and listened to what has been raised, in particular about sections 19 and 20, malicious communication and cyberbullying. And I think the first thing to realize, Mr. Chairman and colleagues, is that I think we have to be careful that we are able to have precision and surety with respect to legislation. I think that we have to be tight, precise, and clear in our meaning, so that if these matters do reach the judicial system, that system and that process also has clarity, and that we can know that prosecutions are likely to succeed if they reach that point. And it is for that reason that I think that to the extent that we can remove anything that may be framed or considered vague, that we should do so. And so I want to offer for your consideration with respect to 19.3. And I would love to have your feedback on this, because these are my reflections and based on some conversation with colleagues, but of course I would love to hear your thoughts. I think an amendment to clause 19.3 that deletes the words "not caring whether they are true or false" and substitutes the words "that are false" and causes or is likely to cause a person humiliation, embarrassment, or reputational injury is guilty of an offense, and so on. And so in that way, I would delete the words ridicule and contempt. And if you don't get tired of my voice, I could go on later to explain why I've opted to delete certain words or offer or suggest that we delete certain words.
Minister, you can repeat what you
Yes.
said there? To delete.
So I would
Not
say,
caring.
I would offer that we delete the words, this is 19.3, the words not caring whether they are true or false, and substitute the words that are false. Because the injury, the crime, the act, in my mind, relates to the falsehood or the falseness, if I were to coin a delicate term, of the utterance or of the image or of the statement, rather than the truth, because that is a far more, perhaps a broader set of considerations. So I would say delete the words not caring whether they are true or false and substitute the words that are false and causes or is likely to cause a person humiliation, embarrassment, or reputational injury is guilty of an offense. And that would have us, if you accept, delete the words ridicule and contempt.
Minister, again, to delete ridicule
Is that
and
line up?
contempt, and you said to substitute reputational.
I can share the language, but
And substitute reputational injury, you said?
so perhaps I should read. So take out not caring whether they are true or false, and substitute that are false. And following on, and causes or is likely to cause a person humiliation, embarrassment, or reputational injury is guilty of an offense. And therefore, if my reading is correct, it would mean the deletion then of the words ridicule and contempt. Now, Clause 20, with respect to cyberbullying, I also think has some scope for us to be more precise. And I think precision strengthens the legislation. So in respect of Clause 21, cyberbullying, I would rewrite paragraph B as follows. For the purpose of causing danger, embarrassment, injury, humiliation, intimidation, hatred, anxiety, or causes substantial emotional distress to that person. In so doing, I have deleted the words annoyance, inconvenience, obstruction, and insult. And I have a method to my characterization of those words. I think that the ones that I am offering for your consideration that we keep are either able to be defined in law and or have their definition elsewhere in law. And so I feel comfortable, and I'll tell you that, you know, I feel that if we separate the fact that I am the proponent of this legislation, I think also the fact that I am a non-lawyer who is myself understanding and perhaps bringing the perspective of a person who may feel uncomfortable with certain of these words and definitions. Now, I have to say that it is my understanding, and I think we have a responsibility, and you in the room who are lawyers have a responsibility to clarify that the meaning of a word in our day-to-day lives need not necessarily align with the meaning of that word in law. And that often these words have accepted definitions in law, but also that these words have an evidentiary requirement. And when I say these words have an evidentiary requirement, what I mean is that you must prove through evidence in the court what you take these words to mean. If I say that something has caused me injury, then there's an evidentiary requirement associated with that word, injury. And so I think it is also our responsibility for those who may be taking some of these definitions in the lay understanding to be able to confirm and to be able to reiterate that these words have a legal understanding and a legal definition and an evidentiary requirement that must be made in court. My other amendments, Chair, really just have to do with the organization of sections with respect to, for example, the word intimidate at section 19.4 may be a bit out of place because of where it needs to be defined. It may need to be defined in a different place. That is something that I'm sure that those who are working on the drafting would clean up. But substantively, I do feel, one, that it is important that we are able to proceed with the protections offered by this legislation, but two, that we're also able to present this legislation and preserve this legislation as something that Barbadians can feel protected by and not persecuted by. And so to the extent that we have the capacity to do that with amendments to the language, but we also have the capacity to improve the precision and the strength of the legislation, then I offer for your consideration those amendments. Thank you.
Thank you, Minister. We will now allow members to engage you on anything that you have put forward or said or proposed amendments you have just put forward.
Sorry, if I may just take 30 more seconds as I look at my notes. There's one other thing that, again, this is the non-lawyer in me, seeking to give people some comfort. I know that the use of the word liable with respect to fines and terms of confinement is understood in law to mean that it is up to, so that $70,000 or 7 years in prison, it is understood. However, if it would not be redundant, I think it would go a long way to include in the language up to, because in the common understanding among Barbadian people, people think that a particular offense automatically, I see people smiling, I'm assuming that y'all have had this conversation already, automatically attracts. Well,
No,
I mean,
no, the Interpretation Act of Barbados speaks to that. So all of our legislation has a maximum fine and/or maximum term of imprisonment. But obviously, within that, there's judicial discretion. So, and yeah, we went through that this morning. So even though it generally speaking says 70,000 or 7 years imprisonment or both, a judge may say, I can just reprimand you and discharge you. I ain't not fining you, I ain't not jailing you. And therefore, judicial discretion must be allowed.
I'm aware
So
of that.
all of our laws, all of our legislative, provisions that penalize have it like that.
Yeah, I'm
the
aware.
drafter.
Yeah, I'm aware of
put
that.
it, so
But I'm
you
also
don't say
aware,
up to.
I'm also aware that some, with respect to data privacy, data protection, and cybercrime legislation, some jurisdictions have opted to include the language of up to, just because it relates to things like speech, things that people do every day, and they have found that in those cases, people want to have a sense of assurance with respect to the severity of the fine. So I put it on the table, being fully aware of the Interpretation Act and fully aware that this is a cap, in a manner of speaking, but I also wanted to put that forward because we understand that there is a certain concern about the level of the fines and the terms of imprisonment. So with that, I'm finished.
Members. Honorable Opposition Leader.
Yes, thank you, thank you. Good afternoon, Honorable Minister. How are you? I just had some very short questions, intending short answers, although I can't tell you how to answer. You would agree with me that legislation, generally speaking, is justified by social need? That's a yes? Yes, that's the question. Would you agree with me that legislation is justified by social need?
I don't know how you characterize social need. The need may not always be characterized as social, but it is, do you mean as in obtaining to the society?
Yes.
Yes.
Yes, so you agree with that?
Yes.
Right. And I take it, it must then be your position that there is a need in Barbadian society for this legislation.
Yes.
And,
but remember, we're not just talking about Barbadian society.
Yes,
this legislation,
well,
cybercrime is borderless.
Yes, it is.
Yeah.
But you would recognize that Section 3 pertains to Barbadian citizens here or abroad.
Yes.
Yes, so it attempts to capture infractions committed by citizens of Barbados. And persons outside of Barbados if the offense affects Barbados, affects the physical borders of Barbados.
Yes.
Yes, good. And now, you spoke of the Budapest Convention, and I take it we now know that there are other countries that have passed this legislation or intend to pass this legislation. Correct?
Yes.
Yes. And that of those, it comes from your ministry.
Yes.
So you're the parent, so to speak, of what is before this country.
I am.
Oh, excellent. Now, can you then tell this country how many countries have passed this legislation? Approximately, doesn't have to be an exact figure.
Let me first clarify that for our purposes, there's really no such thing as this legislation.
Well, similar legislation.
Right.
Yes, sorry.
So 73 countries are signatory to the convention.
That was my next question. So 73 countries are signatory
Yes.
to the convention, including Barbados?
No.
Oh, we haven't signed this yet?
No.
I see. Oh, the orders that you pass and then sign?
Yes.
Thank you very much. So we have 73 signatories so far. Of that 73, how many have passed it?
How many have
How
brought?
many have passed similar legislation?
Most of those 73, and I only hesitate because you say similar legislation, and let me clarify. All of the states that are signatory have introduced provisions related to cybercrime.
Right.
That varies in different ways by having provisions in different kinds of legislation or having a cybercrime bill or act. And the other thing that I should say is that the Budapest Convention is a framework. It offers provisions that countries accept or not. It offers guidance for how to frame legislation, but there is no wholesale acceptance of a particular format. Yes.
Or content. Right. You do know, by now you would, that normally you become a signatory first to a convention, and then you legislate what the convention intends. You do know normally it's the other way around.
Yes.
Yes.
It is.
So,
it is.
in most cases, a country signs and then it legislates. Signs the convention and then it legislates. We agree on that. Could you indicate to us why there's a difference on this occasion?
That is the nature of this cybercrime convention.
I see.
It is, you see, I believe that the architects of this, the Council of Europe, understanding that this is for most countries a brand new area of work, want to give countries the comfort and the capacity assistance, quite frankly, to be able to go at their own pace, to be able to form the legislation according to what obtains on the ground in the country, to be able to get something in place as well that signals intent.
Yes.
To be able to protect citizens in this way. And so the convention is different from others in the sense that it gives support to countries to get this legislation or similar provisions on their books, and then to go further, because being signatory to the convention does take you further to sign the convention.
I see. Now, all right, we've accepted that this one is unusual in that you legislate and then sign the convention. When we legislate then, do the terms of the convention become a part of our legislation?
No.
It doesn't. So what then is the effect of the convention? You have the legislation, which is your law, your municipal or local laws, we call it. Why then, let me ask it this way. Is there a need to become a signatory to the convention?
Becoming a signatory, and as I said at the beginning, it gives you a relationship, it gives you a community of countries that must become your friend on certain matters. What we've done, so when you're signatory to the convention, you then have this network of countries that mutually assist.
Yes.
Because we have not yet signed the convention, what we've sought to achieve that through the Mutual Assistance in Criminal Matters Amendment Bill, which extends mutual assistance in criminal matters. In other words, that countries will cooperate with us for matters of prosecution across borders and so on. That always existed, but we've extended that to include cybercrime. If we had gone directly to the signature of the convention, we perhaps would not have had to do that because that would have been automatic in becoming a signatory.
Right. All right, I accept that. You become a part of a community, and that community, that international community would assist all members in sanctions, so to speak, or implementation, or giving effect to the legislation. It's a community of nations giving effect to legislation.
Yes, and particularly important, evidence and prosecution.
Yes.
Because by its very nature, as you know, these crimes are often being perpetrated against Barbadians by non-Barbadians in other places.
Correct.
And so we may need to request evidence, we may need to request data preservation from the US or the UK or Croatia or Zimbabwe. And so that gives us that.
Has the USA or any legislature within the USA passed the legislation?
Does USA have cybercrime legislation? They do.
I mean legislation pursuant to Budapest.
I believe so, but I can direct you to see the full list of the countries.
Yes, I would want us to be sure as to whether the US is a signatory to the Budapest Convention insofar as it deals with this matter.
That's an easy search.
Yes, please. We have a patient chairman.
Yes,
They have?
yes.
Yes, excellent. Now, the mutual assistance, the corresponding piece of legislation, which is the mutual assistance legislation, that has been passed here?
No, that
Go
accompanies
together.
this, yeah.
Right, precisely. So that the US has also implemented that.
Remember
I
that,
think they've signed, which means that more than likely they have passed.
yes, but remember that once you are party to the convention, the mutual assistance is automatic.
Yes.
Yeah.
Yes, and you did say to us that the US has signed Budapest.
Parties to the Budapest Convention, yes, they're right
Right,
here.
and based on what you told us earlier, if the US has signed, in all likelihood, they have passed the legislation.
The US has cybercrime legislation for sure.
No, we're talking about the legislation prescribed by Budapest.
You are characterizing this as legislation prescribed by Budapest.
Yes.
Let me clarify. The Council of Europe operates at various stages of support to countries. So for example, the council may interact with a country that already has very robust cybercrime legislation. And they're satisfied that the cybercrime legislation is not at all at odds with the convention. And in such cases, may invite a country to sign on to the convention because of existing legislation. So I cannot say to you in the case of all 73 countries that each one has followed the exact process that Barbados has followed. There are many different processes that obtain.
I see. What our representative attorney from CPC will tell you is that nobody pretends to invent the wheel, that legislation tends to copy other jurisdictions, and you would agree that this one is a copy from other jurisdictions.
This legislation, well, first of all, let me step back to clarify something else.
Yes. These are easy questions, though, like Mr.
Yeah, and these are easy answers.
Excellent.
So we had a Computer Misuse Act,
Yes.
right? And so I can share this with you if you like, but there are certain offenses that are established as offenses under the Computer Misuse Act that are simply imported into
Yes.
the cybercrime bill,
Yes.
right? And then there are others, and remember too that the reason that this was a subject of the law review and came to the attention of the Law Review Commission is that by its very nature, technology offenses are changing all the time. And so we needed to be able to review the Computer Misuse Act and say whether some of these things needed to be updated, whether there were types of crime or types of data or systems that had not been contemplated in that act. So in answer to your question, I'm clarifying that if this is a copy of anything, it leans heavily on the pre-existing Computer Misuse Act of 2005.
Yes.
But then it leans then on the Budapest Convention to be able to update the legislation to make it fit for purpose today in a 21st century Barbados.
Yes. So what we are agreeing then is that this legislation is much like other pieces of legislation in other countries.
As most legislation is.
Precisely, that's the point. So that no one has reinvented the wheel And I take you back to the United States then. Would you say, you use the word robust, a word I love actually in this context. Has the United States been more robust in its drafting, or has it been pretty much in line with what the other countries have done?
I can't say.
You don't know. I see. But what we've established is that we can say that this legislation is, I'm going to use the word harmonized. In terms of its content, it is pretty much harmonized across the Budapest Convention countries. In
Yes.
its content, yes. But you will accept, Minister, that there are some variations from country to country.
As there must be, yeah.
Yes.
There are variations in ours as well.
Yes, precisely. And there are variations in ours because you, as the parent, I like the term, as the parent of this legislation, you have considered that there are peculiarities within the Barbadian system that require us to vary from the harmonized legislation. I could rephrase that.
I think that we have a duty to make our legislation fit for the context in which we're administering.
Precisely. Because ultimately, your position must be that the law must operate within a social context.
That's almost rhetorical, yes.
Precisely. That you don't pass a law that is not, you use the word fit for purpose, a phrase I don't like. A law must be relevant to its context.
Yes.
Yes, that is almost rhetorical too. So that you do recognize that, and when I say social, I include the political. Yes? Yes. So that you recognize that our social context is different from all other social contexts in which this similar law has been passed.
Our social context is in some ways very similar and in some ways different.
Okay, similar to whose?
To many other countries.
Right, okay. Now, our chairman here tells us that Guyana has passed this law. Well, not this law within the framework of Budapest, the Budapest Convention. So,
Guyana has cybercrime legislation.
Yes, yes. He speaks with some authority when he says that.
Okay.
So, unless you
I
want
defer
to
to his
disagree
authority.
with him. Minister, you would, I'm sure, accept that Guyana presents a different political culture from Barbados. Political and social context.
In some ways,
In fundamental ways. I'll give you, you wish me to give you some examples then. The Guyana Constitution, for example, is classically a republican constitution based on Guyana's peculiar political context, political culture, beg your pardon. Certainly they have proportional representation, which we don't have. And if this does not make you feel squeamish, they have a party system that composes itself along racial lines. We don't have that here. You agree with that? I think we all in this room know that, and I don't think you'd want to disagree with that. That is the political culture of Guyana. A party system in which its party composes itself along racial lines. The PNC, I'll tell you, the PNC is predominantly black, and the PPP is predominantly Indian. You know this.
my objection or my hesitation is in your framing of composes itself along
Well,
racial
the
lines.
parties are comprised. The PNC is comprised largely of an
Right.
African
Yes,
population. The
that's
PPP
correct.
largely of an Asian population. You
That's
agree with
correct.
that? And that composition affects the political culture.
Is that a question for me as
Yes,
well?
yes. You can just agree and we'll go on smoothly.
Well, take it that I'm agreeing to all of the preamble.
Yes, but the chairman wants you on record, you see. And it reflects in Guyana that, let's call it that two-party dichotomy, reflects social tensions within Guyana society. I hope they're not hearing me for speaking these truths in such a place as this. But you would accept, Minister, that there are tensions between the two political parties that reflect wider social and racial tensions in that society.
Honorable Member, if that is your premise,
No, it's
then-
a question, it's a question. You either agree or disagree.
yes, but
And you're a historian of
am
some
I?
merit. Yes.
Apparently, I'm not an economist, so it must be something. I accept that this is your premise.
No, it's not my premise. Those are
Uh-huh.
questions, Minister. Those are
So
questions.
frame the question again.
Do you accept that the Guyana, the two-party, well, there are more than two, but two dominant parties, that two-party dichotomy reflects certain social and racial tensions? Do you agree with that?
I think it, yes, reflects, as in reflects back to the society, certainly.
Precisely, and it reflects those tensions that exist between two groups, two racial groups.
I think it reflects, it reflects a particular dynamic
Right.
that, that citizens have to contend with.
Yes, and you would go on to agree then that those tensions of that nature are not present in Barbadian political society. Of that nature, I
Honorable
say.
Member, I don't know what road you are trying to take me down with you, but you will be going by yourself.
Don't be afraid, Minister.
You are free to share whatever premise
No,
on which
I
you're
am not.
operating, but
I am not sharing a premise. I'm asking some very easy questions.
I
and
am
you're
not
doing
sure,
well
I
in
am not sure
answering
that
them.
I agree.
I don't know why you're resisting
I'm
at
not
this
sure that I
point.
agree. I think that let me say this. I think that our islands in the Caribbean present, by virtue of their race-based past, all kinds of tensions. I think that in some countries, we have not had a reckoning.
Have not had
A reckoning.
reckoning. Strong word.
We have not had a reckoning. We have not had a reconciliation. And that presents in various ways.
When you say we, you mean we in Barbados?
No, we across the
Across the
region.
Caribbean, yes.
And so we've gone through that process in various, to various levels, right? So it means then that what one might perceive as an absence of race-related considerations may not be so. So I don't know that you will get me to agree with some of what you're saying, but I await the question related to the legislation.
Yes, I'm coming there.
Great.
I'm coming there. And we started nicely on legislation and the content of legislation having relevance to its social context. That's where we were. And you agreed that legislation must be relevant to its social context, social and political context. Because legislation, as you further agree, is an instrument of political power. People who have political power pass legislation. The parliament in which you sit. I don't have any power there.
You.
If I vote for it. Now, all right, so we're back at the question of social and political context, and you are about to answer as to whether you consider that Barbadian society and the Barbadian polity mirrors that of the Guyana society. In terms of, another term used in terms of its dynamic, we spoke of the dynamic in Guyana. And I'm choosing Guyana because that is one of the countries that has passed the legislation. And I'm asking you if Barbadian society and the Barbadian polity mirror that of Guyana.
I don't think that any country exactly mirrors, and that's by definition what mirror means. I don't think that any country mirrors another. I think there are, with respect to certain areas of law, sufficient similarities in countries that mean that legislation is applicable or can be made to be applicable in both. They do not need to look exactly like each other
Right.
in order to warrant the legislation.
Yes. All right, so we've agreed that Guyana presents as a society with racial tensions. And you will agree, I think, that Barbados does not present with identical tensions as obtained in Guyana. I think you'll agree with that.
Somehow I feel as if I passed this road before.
You mean on another day or a few
No,
minutes
I
ago?
mean a few seconds ago.
Oh, okay. Okay.
I think I've clarified that the two countries have some things in common and some things not.
Right. All right, I'll press on. I appreciate the difficulty in which you find yourself. So that you will agree that legislation of this nature passed in Barbados ought not to be identical with legislation passed in Guyana.
I make no such concession. I don't know on what basis I would say that a piece of legislation passed in Barbados ought not to be identical.
No, I'm asking, I'm not
I don't
asserting
agree.
that.
I don't agree with that.
So your view is that our legislation can safely be identical with that of Guyana's?
I think, honorable member, that you take.
Don't get upset, don't get upset.
No, I'm not getting upset. I am surprised.
No, I'm asking a simple
by
question. I'm asking if you think
And please
that-
permit me to respond.
I beg your pardon.
Yes. So I am saying that you take legislation on its merits,
Yes.
right? The fact that I may not look exactly like you or walk like you or talk like you
You're better looking.
does not mean, I hope so, does not mean that we might not both choose to wear the same hat or the same watch. So I'm saying to you that what I'm sure the Republic of Guyana did in their case, as Barbados did, is to go provision by provision in the Budapest Convention to
Yes.
consider the extent to which
Precisely.
it was suitable for us,
Precisely. And for them.
for Barbados.
Yes.
Yes, that's what we did.
Okay. All right, let me simplify it. You haven't seen the Guyana legislation, have you?
I have not read it in detail.
You've seen it, but
I've seen it.
right. So it would not be correct for you to say, I've seen it, I've read it, and you can't make a comparison between the Guyana and the Barbados legislations.
Specifically, no.
No, precisely.
Oh, Honorable Member, just trying to see where you're going with it.
Where I'm going?
Because Jamaica also has
But I am
similar
going to ask some
legislation.
other questions. That's where I'm going.
Right, I know.
I
But
haven't
you were
got to Jamaica.
focusing
I'm not
on
going to
Guyana.
Jamaica. You have
No.
told this body that Jamaica
Right.
has passed the legislation, and further to
Jamaica
telling
and
this body
Guyana.
that, I am
Both of
asking
them.
questions about Guyana. Only because you have told this chamber that Guyana has passed similar legislation. As to where I'm going, I am going
Right.
where you led us.
Right,
And
but-
make inquiry about a comparison between Guyana and Barbados. If you had said St. Vincent, I would have asked about St.
But you could come to the point, because I mean, it isn't on all fours with Guyana.
Well, that's the answer I want.
Right.
So thank you very
So,
much, Chairman.
I just
So
say-
that, Minister, we have the
Because the
answer.
minister says she hasn't read it. But,
Right.
But I
right.
have.
And you provided the answer.
Right,
I'm
it
obliged.
isn't on all fours.
Good.
no.
Now, you had told us, I'm obliged to you, Chair. Good. You had told this body, Minister, that legislation must reflect a social need. And I think you say that there's a need for this legislation in Barbados.
Yes.
And when you think, and obviously this is a need to protect persons and their reputations, That's largely what we're trying to do here, aren't we?
No, it does more than that. It is aimed to protect people
Yes.
and their reputations.
Yes.
It is also aiming to protect information and systems.
Yes.
It steps away from the reputational with respect to protection in the provisions related to child pornography.
Right.
And so on. So it's quite far-reaching.
Yes, yes. Well, I'm not going to deal with all exhaustively. I'll just start with people and their reputations. So that we have from you that a part of this legislation is intended to protect people and their reputations. Not trying to trick you, so not setting you up.
You're repeating, so I
Yes,
think a nod
okay,
should suffice.
Good. No, I want clarity here. I want you to understand everything I'm asking and to be assured that I'm not setting you up. This is no trick. We're doing this to satisfy the public that this legislation has some kind of legitimacy or validity. So let me ask you, is it possible to have a regime of law in which you seek to protect people and reputations without also criminalizing the perpetrator of?
Sorry, could you repeat that?
Yes. We have agreed that a part of the purpose of the legislation is to protect people and their reputations. We've agreed on that. And trust me, I'm asking this to reflect public sentiment. That's my role here. I think part of my role is to reflect public sentiment. Now, is it possible to protect people and their reputations without at the same time criminalizing the action of the alleged perpetrator? Is it possible to have a regime of law in which you protect a person's reputation without also criminalizing the alleged perpetrator, and that perpetrator being the person who has offended the person's reputation?
No.
It is not.
No. So let me tell you why. And I said it in my opening remarks. I don't think you had joined us yet.
Yes.
I think that we have enough evidence now of a level of injury, damage, hatred associated with these kinds of crimes that supports taking these matters into the realm of criminal prosecution. And so I think that it is not possible to offer the level and the assuredness, the depth of protection without applying criminal prosecution.
Thank you. That's a rather bold statement, and you did mention the word hatred. And those who have studied their history, including biblical history, will tell you that hatred now is no more visceral than it was from mankind's earliest days, humankind's earliest days. The difference now is that it is precisely where this legislation seeks to prevent it, in cyberspace. But humankind has not changed. Well, let me not make a speech. Humankind has not changed. Humankind is as hateful now as he always has been. The difference is the transmission of that hatred, to use your word. So that what you're saying to us is that this legislation is employing the criminal law, not so much to condemn changing attitudes, but to condemn the transmission of that attitude to people as far away as China.
I don't know what you mean by condemn the transmission of the attitude. If you look at the,
Well, the cybercrime,
right, but
I
it's
can
not,
say
but
something
it's
on my
not
phone now.
condemning transmission, let's be clear. And if we come back to,
The spread of the thing.
no, but it's,
We are penalizing the spread of the thing,
but you
not,
asked,
not
if
the
you
thing
ask me a
itself.
question, let me answer, right?
Yes, I beg your
So,
pardon.
so, I don't, no, this legislation is not condemning transmission and spread. It is condemning what a result. So it is not just the fact that something has been passed or sent. It is that it has been passed or sent with the intention to do harm, and that that harm has been done. That's what we're criminalizing.
This, if it becomes law, it will be called the Cybercrime Act. The Cybercrime Act. Yes?
The cybercrime bill, yes.
Yes, if it becomes law, he said it would be called the Cybercrime Act. So that the mischief that we are protecting against, which all legislation seeks to do, the mischief we are protecting against is that ability of the internet to spread mischief instantly and far and wide. In other words, in cyberspace.
Honorable member.
You're stopping me, Mr. Chairman?
No, but hold
How many
on.
more questions do I have?
Hold a bit. The minister has answered saying that, in her opinion.
Yes. Oh, you're answering for the minister?
No.
Oh, I see.
As I said, she said that it is her belief that you have to have a criminal penalty to.
Yes, and I'm responding to that.
Right. And you did say that you're not making a speech, because remember, we brought her
No, I'm
here
asking a
to
question.
engage and then to
Yes,
ask questions.
yes.
So you could move
So
on
you
to
don't
the
wish her
question.
to answer the question?
No, move on to the question. Don't make the speech.
No, I'm not making a speech.
Because I'm sure there are other members
Yes,
who
yes,
also want
yes.
to engage.
The
I
minister is
certainly
the
want
last
to as well.
of our guests today, and leave. Yes. Now, Minister, I was asking this question. I was asking whether the legislation intends to prevent the mischief of quick spread of abuse through cyberspace. Is that a part of the mischief? Is it not a part of the mischief that this legislation seeks to prevent? That misinformation, hatred, offensive statements can travel quickly across borders.
Right, it is a consideration of the legislation. The reason that the legislation is framed in this way is that these communications do, by their definition, go quickly. It is a consideration of the legislation.
Indeed.
It is not meant to address the speed at which the communication goes. Legislation can't do that.
I see. Now, it is called cybercrime, the cybercrime bill. And I take it that cybercrime derives from cyberspace, correct?
Yes.
Yes. The phenomenon of cyberspace, a place that is borderless, correct?
Correct.
Yes. Don't mind, sorry. So that I was asking you whether this legislation does not seek to control expressions, and I'm going to use your word, expressions of hatred or offense across cyberspace.
The legislation seeks to address the harm that is often caused
Yes,
when a person with intent
yes,
and without authorization cause certain communication to be shared, cause certain data to be compromised, cause certain systems to be accessed. That's
Yes.
what the legislation seeks to do.
Yes, but we have all that, but I am on the question, and I'm on this deliberately. I'm on the question of offense against individuals and their reputations. I haven't gone to data. In fact, I'm not going to go to data and the infringement of data. I am on the issue of the offense to persons and their reputations to which they're entitled. And I'm asking you, if this legislation does not seek to protect persons and reputations because it is possible and easy to commit the offense across cyberspace, a place that is borderless, is that not one of the primary intents of this legislation? To protect reputations where the propagation can be committed in cyberspace and reaches anybody, any part of the world? Don't answer me, Senator. It's not your question.
I don't know how many different ways I can answer the
Don't
question.
look at him.
No, I can look anywhere I want with all
I
due
know,
respect.
I know,
honorable member.
but he can't help you.
But he doesn't need to help me. That's the thing.
But he wants to, and I'm telling him mind his own business.
So let's focus,
Yes.
right? The legislation, I feel like I have answered this.
Okay, if you've answered it already,
several
leave
times.
it. Good.
Yeah.
You uttered a word that caught my attention. And you uttered the word hatred, okay? And that caught my attention. And I responded by suggesting to you that hatred now is no more visceral in the bosom of humankind than it always has been. That was my response. And my follow-up question to that, in fact, I will ask, do you agree with that? That hatred is now no more visceral than it always has been? But you mentioned hatred. You introduced it into the dialogue.
And it seems to have set you off on a
Yes,
complete tangent.
you have, because I will come next to who determines the punishment for this hatred.
Well, I would encourage you to focus on the provisions that are expressed in the bill.
Yes, but
and not to get sidetracked by my
No, I'm
language
not
here
saying
today.
that. You are the parent. You began by boasting that you are the parent. So let us hear what the parent thinks of her legislation.
First of all, I boasted of nothing. That was your characterization.
Which you
as
accepted.
one, right?
Which you
So
accepted.
you framed me as the parent. This is
You didn't reject it.
this legislation is, by the time you have finished with your work, it will be the result not just of the government of Barbados' considerations, but also the people of Barbados' own input and reflection. So
All
that's, so that's the first thing.
Yes.
What I'm saying to you is, I would encourage us to focus on the language that is reflected
In the
bill.
legislation.
Yes.
Right. But if you come to defend it, you are deemed to be the person influencing the meaning and the intent of the legislation. When the courts pour over this, they always ask the question, what did Parliament intend? And here we have the parent of the legislation, the privilege of hearing the parent of the legislation, and this parent can tell us what this Parliament intends.
Honourable member,
just let me finish the
I think the
question.
minister has answered
Yes,
that.
and I'm on to the next,
I
she has
don't want
answered
us
that
to
question.
go over.
And I'm on to the next question, there's nothing to
Right, the
protect
next
here.
question, next question.
I am doing this in the interest of you know, a proper understanding as to the intent of Parliament. Now, I think you told us, and I'm going to remind you of this before I move on to the question that follows. You told us that it is not possible to protect reputations without also criminalizing the perpetrator. You say that.
I answered you very specifically. I said that given the level of injury, damage, and so on,
Hatred.
that can often obtain in these circumstances.
Yes.
You are the one who raised the issue of legislation being fit for the society. And I'm saying that given the level of injury and damage that we see in these cases, it, in my estimation, causes these matters to raise to the level of criminality.
Precisely. That's a long way of saying the same thing. That the possible injury is so severe that the civil law does not offer an adequate sanction. Is that what you're saying, Minister?
I also offered another.
No, I'm asking if that is what you're saying to
Yes,
this
but I'm
country.
saying I also.
Let us be clear on this. Let us be clear. Let's not argue. You're saying to this country that the possible injury is so severe that the civil law does not offer an adequate sanction.
I
Is that your
also
position?
offered. This is
No,
not
no,
a
that's
court
the
of law.
question.
But
That's the
but I'm
question.
answering.
No, you can
Honorable member,
clarify further.
This is not a court of law.
That's a direct question. That's a
I
direct
answer
question.
how I see fit.
Sorry, Minister. All right, I have it on the record then. I was giving you the opportunity to say yes or no. If I were you, I would have said no.
But you're not me, thankfully. So you continue.
I am equally grateful. Now, I am saying it is now your evidence before this committee that you consider that it is not possible to use the civil law. Let me put it differently. You're saying that the civil law does not offer adequate sanction against the injury contemplated by this legislation. That's what you have said. Now, this legislation goes farther than the civil law and offers the sanction of imprisonment, correct?
Yes.
Good. Are you aware that the civil law offers sanctions which are capable of ruining a person financially? Which is, I mean, there's hardly any greater ruin than that. Are you aware that the civil law offers sanctions which can ruin a person financially, that he can lose everything he has?
Let me repeat the other qualifications I offered. Again, I'm not sure if you were with us at the time. To support why we believe
Yes.
these matters need to rise to the level of criminality. I mean, as you should be aware, there is criminal libel existing in law already,
Which
right?
this proposes to abolish.
Right. So I'm saying it is not foreign to our sensibilities to have the notion of criminal libel, and I would not want anyone listening to this conversation to suggest that bringing this to the level of criminal proceedings is new. It is simply taking the notion of criminal libel, preserving it in this law, but then allowing for defenses at 19.5 that preserve a person's freedom of speech. So let's not suggest that bringing these matters to the level of criminal prosecution is new. But I also offered that one of the reasons I believe that we must use the parts of the law available to us is that civil proceedings require resources, require means. I can't tell you, I grew up in a village in Haggett Hall. And it is not to say, you talk about how hatred has existed forever. It is not to say that people have not been aggrieved, poor people have not been aggrieved before, but if you are a poor person who is aggrieved by something somebody has said about you, you are very little able to be able to pursue that person, to get any restitution in civil proceedings. Why? Because I cannot afford a lawyer. I cannot afford the time from work or the daycare to show up in court all the time. There is an extent to which we as the state have to stand in the breach for those people whom you and I represent, Honorable Member, who cannot so do for themselves.
Okay. So that what we glean from what you're now saying further, and I'm grateful, is that this legislation assists with a criminal sanction for the sake of alleviating. You're gone, Minister?
No, I'm saying that, and I'm aware that other members.
Don't worry about them. They're doing this for who they're doing it for. You're doing this for the people. So please.
Honorable member.
Mr. Chairman,
Mr.
Chairman,
But Minister has spoken
right?
very clearly
Mr.
and
Chairman.
is emphatic in her answers. You may disagree.
I am not
with her.
disagreeing with anything. I
No,
am
but
asking questions.
it is no use trying to get more out of her. She's spoken with clarity
But this is the
as
minister
to.
who is responsible
No,
for the
but hold on.
legislation, and the people of Barbados are entitled to hear what is in
I
the mind of the
know,
minister
but she's
who is responsible
she's
for the
spoken with
legislation.
clarity
I
and
agree that she
emphatically
has
as
spoken with
to it.
clarity, and I want some more
But you're not going
questions
to, you're not going to get more by
How do you
just
know that,
repeating
Chairman?
the same
Every question
questions
I asked,
and
the
issues.
minister has answered every question, and I have another question to ask.
But not
You may not
on
like it,
what,
but I
hold
don't
on.
think the
But
minister shown
not,
any
but not
disdain for
on
the
what,
question.
not on what she has already responded.
No, this is a different question, with all
Okay, so
respect.
let's hear the different
Good.
question then.
Different question. Minister, based on what you've just said, that the poor man cannot afford to pursue the civil sanction, that's the last point of departure. And I'm asking based on that, Minister, are you saying that this legislation, in the form of its criminal sanction, compensates for a poor man who does not have the resources to pursue the civil sanction? Is that what you're saying?
What you are asking me is a particular characterization of something that I've just been very clear about.
No, you just gave the instance of a poor man being unable to pursue a civil sanction. You said it in more words than that, but I am summarizing it. You said a poor man does not have the resources to pursue the civil sanction. There's time, he may be at work, and he needs money for lawyers, that kind of thing. I therefore ask you, as parent of the legislation, is the criminal sanction a compensation for the poor man who may not be able to pursue the civil sanction?
No.
Good, excellent answer.
Mr. Chairman, can some others be able to ask questions, or?
You mean during my questions or
No,
after?
I mean, I just want to know because the minister had indicated that has somewhere else to go.
Oh, I see, I'm sorry.
And so
I'm sorry.
we also are members of the committee.
Honorable member,
I'm
I'm going to ask you to
To wrap up?
kindly wrap
Yes,
up.
I will
Yes,
wrap up.
because
I will wrap up. I didn't know
He's
that.
had more than he's had more than a
I didn't know
hour.
that the minister and Senator Nichols had to go somewhere. I'm sorry about that.
I don't have to go anywhere, but I would
Oh,
like
you
to
don't?
also ask some questions to the minister. And
We've asked the honorable member to wrap.
Yes, I'll wrap up,
Yes,
Chair.
please.
And I appreciate your last answer that one is not done as a compensation for the other, but you did say it. Now, the question of jurisdiction, perhaps I should not ask you that. I probably should have asked Sir David that, the question of jurisdiction. Do you contemplate, Minister, that this legislation will be able to capture persons who commit the offense within the United States of America or England or Canada? Let's go for those three countries. Do you contemplate that the legislation will be able to capture persons who commit the offenses in this act within Canada, the United States, and England?
So I am pausing to consider your framing of the question to make sure I
But
respond
they didn't want
precisely.
they didn't want me to ask it, so I could withdraw it, and you wouldn't have to consider it.
Well, now you've posed it, so.
Thank you very much. So
me
you're
consider
cooperative.
it. Do I consider that this legislation will be able to capture persons, do you mean? it would-
Offenders
Right,
in
but I'm-
Canada, the United States, and England.
Right, you've used the word capture, so I need to make sure that I'm understanding you correctly.
That you can charge people, that the police here will be able to charge people who commit these offenses under this legislation in Canada, the
Yes,
United States, and Britain.
in other jurisdictions that are,
I
with whom
focused
we
on
have,
3.
with whom, in other jurisdictions with whom we have agreements related to mutual assistance in criminal matters.
Right, and you've told us the United States has signed Budapest. Canada has signed as well?
The United Kingdom has signed.
Yes, we know the UK has signed. I'm asking about Canada. Because this is a promise I'm now going to make to the people of Barbados, through you.
Canada is party to the Budapest Convention.
Precisely. So that it is intended, Minister, that this legislation will cause the prosecution of persons who commit these offenses in those 3 countries, correct?
No, it is not accurate to say that it is intended that this legislation will cause the prosecution of persons. And I think your language is very loaded.
Yes.
Let me put it this way. This legislation and the Mutual Assistance in Criminal Matters Bill, once it passes, allows us to be able to pursue the gathering of evidence and the preservation of data in jurisdictions outside of Barbados as applicable.
Honorable member, you've had a long
Yes,
run.
I will wrap up. I
A
will wrap up.
long
I
run.
will wrap up. Chairman,
And
I
we
will
have
wrap
to
up.
be
Please allow me
fair.
to wrap up, please.
We have other members
Please allow
that
me to
want
make
that.
one further sentence.
One further sentence.
One further
One
sentence.
further sentence, yes.
And to say to you that Section 3 of the Act says that the Act applies to an act done or an omission made, A, in Barbados, B, on a ship or aircraft registered in Barbados, or C, by a national of Barbados outside the territory of Barbados, if the person's conduct would also constitute an offense under the law of a country where the offense was committed. That is a matter, a legal question of jurisdiction. I will not disturb the minister with that, but you, as a lawyer, I am saying that to you so that you will understand the question of jurisdiction and that this legislation is intended to capture persons who commit the offense outside of Barbados, including Canada, including the United States, including Britain. I'm obliged to you.
Let me just react to that.
Yes, please.
Last sentence. So by its definition, cybercrime does not have any borders.
Yes.
And so it is possible to sit in Romania, in Senegal, in Malta, in Canada, in the US, and commit an attack on the systems, the critical data and infrastructure systems that Barbadians need to survive. It is possible to sit anywhere in the world and cause a Queen Elizabeth Hospital, a polyclinic,
Data breaches.
a floor, a light and power, to absolutely shut down for days. I don't have to be here to do it.
Right.
To the extent that I don't have to be in Barbados to do it, there has to be a way for any state to pursue these criminal activities that can debilitate its government and its people wherever these offenses are taking place. Barbados is not the only country that recognizes that.
Precisely. And that question of jurisdiction extends to people's reputations. Thank you for the answer. That in relation to people's reputations, the offenses can be committed any part of the world. Thank you, sir.
Okay, Senator Nichols.
Thank you, Chairman. I'm not going to be emotive at all or lobbying insults across here. Now, I want to deal with some of the points that I thought came from your presentation, Minister. I thank you, and I believe the country thanks you for speaking again with such clarity on this bill. Now, the bill is about cybercrime, Minister, not cybersecurity, not compensating people for injuries suffered as a result of any infringements to their rights in cyberspace or so forth. Now, I believe one of the comments or the context from which Mr. Thorne spoke was about cybercrime and cyber offenses and criminalizing the offender, and if this could be achieved by way of a civil redress, by way of civil law. What was your response to that? Because I didn't think he allowed you to finish your answer. Can this be addressed by way of civil law, or this is something altogether different, cybercrime? That's my first question.
I don't think that these matters can be addressed in the realm of civil law. I think, first of all, that what the world has been doing is setting up what is essentially a criminal framework for these matters. And the only way it works is if we, as in states across the world, jointly consider applicable criminal prosecution in these matters. So, for example, one of the things that caused people to receive no justice for offenses against them was the fact that we did not have this cross-border jurisdiction in civil matters, so that those who tried to bring action, civil action against people who may have been in, I shouldn't say Serbia a lot, Luxembourg or Croatia or the US, those who tried to bring action, civil action, were not able to proceed because there was nothing that allowed them to reach across those borders, notwithstanding that the crime was borderless, to be able to pursue that. And so for many reasons, for the reasons that I've already outlined, because of the fact that civil pursuit did not allow you to go across borders and gather evidence from other jurisdictions, it simply is not possible to address these matters in that realm.
Thanks, Minister, because my research is suggesting that whereas cybercrime costs the international community about $6 trillion 3 years ago, it is likely to cost in excess of $20 trillion by next year. So this is not something to be trifling with. Now, you were asked about Guyana, and an attempt was made to distance or to make some distinction between Barbados and Guyana in terms of the social and political setting. But I looked at the Guyana Act, and just quick yes or no. So Guyana has misuse of devices, computer systems, and access codes, critical information infrastructure systems, computer-related forgery and fraud, child pornography, child grooming, online sexual abuse, cyberbullying, cyber terrorism. These are the things that are mentioned in our legislation and in theirs. Guyana, between sections 3 and 24 of their act, lists a number of cyber offenses. Jamaica, a similar thing. Do you think that things like child pornography, child grooming, cyberbullying, cyber terrorism, malicious communications, that has anything to do with the social or political reality of the countries that we're dealing with? So as to justify changing the legislation based on the political culture?
Look, I think that there's a reason that we see legislation that looks very similar across jurisdictions, and especially jurisdictions in the region. I will confess that I did not gather the meaning of the line of questioning, the related line of questioning earlier, but I will say this. A a few things. One is that the provisions that you just outlined that are common to the two pieces of legislation are common to the two countries. And they're common to many countries around the world. But not only that, let's understand the importance of contagion and cross-border transmission. It really means that this notion of a society, a physical society on the ground that is separate from an online society, is a fallacy. There is a culture, there is an experience that our children and women and other groups of people who present particular vulnerabilities, who may present particular vulnerabilities in that sector, experience. That is not mirrored in Broad Street or in the Demerara. It is not about that. This is about the experience of living and working and having your being in an online environment. And so that online environment is the great equalizer for what many of us experience day to day. I will sit, and I'll give an example. I have a godson who's into gaming. And he sits, and ironically, one of his best friends is in Guyana. He sits in his living room. His friend in Guyana is in his. Another friend is in Prague, a close friend of his, a girl that he is often gaming with. These young people are sitting all over the world. Their reality and their society is whatever is happening there. So whereas they might be speaking French outside for one, or they might be speaking Spanish, or they might be a fishing village outside, or they might be, that is irrelevant. The fact is that there are certain vulnerabilities that attach to an online environment, there's certain realities and there's certain risks that equalize this all across countries and cultures.
Thank you, Minister. I'm looking here at the Guyana Act and Section 19. I'm sure you may not have this, but it says here, using a computer system to coerce, harass, intimidate, humiliate, etc. a person. Seems very similar to our malicious communication offense, and may I also take the time to remind that we had malicious communication as an offense under the Computer Misuse Act of 2005, and it's almost impairing material what is in the bill, which is why it's surprising to me that it's now so alarming to the public. And Jamaica, who is also implementing this legislation, also has malicious communication almost in similar terms. So that a lot of some of the public criticism is that this provision was being placed here to silence criticism, particularly of the government, and criticism of politicians and so forth. You've offered up today a number of suggestions to change some wording and stuff within Section 19, which is the same malicious communication. And I just wanted you to expand a little bit on the context of that.
Yes. So, first of all, I think I prefaced my proposed amendments by saying that we took particular care to, in the defenses, the clause that relates to malicious communication, clause 19, we took particular care to, in fact, preserve freedom of expression through the defenses that are set out at 19.5. So we understood that we were bringing the idea of criminal libel into this legislation from the Defamation Act, and we wanted to make sure that the defenses of truth, comment, triviality, and privilege, whether absolute or qualified, provided for under that Defamation Act will also extend here. so that if what is being said is true, and the other defense is represented there, that is a defense here. I think it's also important to reiterate what 19.1 says. A person who intentionally or recklessly uses a computer system, intentionally or recklessly. At 3, a person who intentionally uses a computer system. So again, there must obtain the will, the intentionality to do harm through the actions. But let me come to your question in terms of the amendments that are proposed and why they're being proposed. As I mentioned, I'm offering, and I'm saying, offering for your consideration. The truth is that we have in the bill a person who intentionally uses a computer system to disseminate any image or words, not caring whether they are true or false. To the extent that the mischief is in the falsehood, my thinking, our thinking, is to dispense with the burden or the provision or the consideration of truth and to focus on the consideration of falsehood. And I think that perhaps may put at ease those who feel that, notwithstanding that there must be intentionality, notwithstanding that there are defenses, who still feel that this legislation creates some discomfort when it comes to the issue of freedom of speech. We think that because the mischief is in knowing or not caring whether something is false, so in other words, you consider that this thing has a good likelihood of being incorrect, untrue, false, and you persist intentionally with its dissemination. So that was one of the considerations there. I think the other amendments suggested relate to 20 cyberbullying.
Just one question in 2 parts for me, Chair. Is there any scope for any compensation or restitutory orders being made by the magistrate? Because you did make reference to the fact that the standard of proof is beyond a reasonable doubt, which is higher than on the balance of probabilities, which is, by the way, the standard in a civil case. So if the standard is higher for the criminal case, is it within your contemplation in the future that some guidance could be given to allow the courts, either by way of legislation or by orders, for guidance as to, I know there's provision in the bill for guidance, but I'm talking about giving guidance on these amounts.
Are you sure you want to ask Minister Marshall that Minister Marshall is not a lawyer?
With all due respect, Chair, we are all legislators in here.
Yeah, but under the
Sure.
under the 1997, I can't remember the exact name, penal act that would have been passed here in Parliament.
Penal System Reform Act.
Right. Restorative justice is always an option.
Yeah, but there's a provision in this act for compensation. So I'm not asking about whether we can, because the jurisdiction to grant compensation is here, but I do believe that this legislation can only work in certain parts if there is guidance given and regulations issued into how certain things are to be operated and eventualized. So I'm asking whether or not that is within the scope of what, because the ministry will have to issue such guidance, or some ministry, or some authority of the government. So that's why I'm asking the question, Chair. Is either not contemplating it now, or because you don't want a situation where then is left to the magistrate in District C or the magistrate in District A to determine compensation or what guides compensation. in relation to these matters, because this legislation is sui generis. This is not anything of a similar class that exists right now, so that orders for compensation, which is, creating this a recoverable civil debt against a person who has made a malicious communication via some internet device or computer device. So that is the question I wanted to have some clarity.
You're asking if there's scope, which is a pretty low bar. I would say there is scope. I take your point, your meaning, that, and it is something that I've also reflected on, that there are cases, there are scenarios of criminal prosecution in which restitution alongside the criminal penalty perhaps serve the offended party best, or perhaps serve best. And so I would not want to say that it is beyond the scope.
Because Section 30 does give you the power to make regulations, which comes after Section 29, which is the power to order compensation. Yeah.
Yes, and I think that in that section, it makes it possible. I wouldn't want to say that this is something to which we would go immediately. But as in other areas of legislation, yes, I think it is within the scope. And I do see the value that could obtain in the future for such cases. But let me do clarify though that I want us to be clear with our purpose in this legislation, right? Which is that there is an extent to which there's public damage as well that is caused by these offenses. And that's another reason why I believe that civil pursuit does not serve completely. I mean, when you have a case where, or a scenario or a situation where attacks made or harm done in this realm continue unchecked, that contributes to a certain sense of disorder and absence of governance. And so I say that to suggest that there is apart from the injury to the person, there's an injury, there's damage to the society when these things are allowed to stand. I really encourage Barbadians to not be sidetracked by the overemphasis on a particular area, and to be reminded that this legislation is one about protecting people's information. It is about protecting children in an online environment. It is about making it so that what happened to those two women in the context of the US election, where they lost their reputations, their safety, their work, their homes, that is not something that takes over. That is not something that is done as a matter of course, that people feel that there are not consequences for the utterances that they make. There are consequences. There have always been consequences for the ways in which we speak about people, the ways in which we gain access. You know, the truth is that a lot of what is covered in this legislation, it is akin to gaining unlawful access to a person's home. Being able to break into the systems of the state where there's information related to an individual. That is what Barbadians are insisting on. They're insisting on the kind of data protection that this legislation allows. And that is why I said at the outset that pausing this bill to have these conversations allows us to reflect on what we want. Bajans have said very clearly that they want this kind of protection. We all know, I dare say in this room, people whose lives have been very adversely affected in Barbados by the kinds of actions that this legislation criminalizes. So I do want us to step back and consider this thing in its entirety, to be able to understand that this is primarily about protecting individuals who can ill afford to protect themselves. Most of us in here don't need the state to represent us if somebody says something about us that cannot be supported or that does damage to us. I keep hearing thrown around this room this afternoon this notion that I am speaking for the people outside. Look, this legislation is speaking for the people outside. This legislation is about making sure that even in cases where a person does not have the wherewithal, the resources to defend against these kinds of attacks, that the state is going to step in on their behalf. And so I do believe that we've listened. I certainly have in my own reflection, and what you've heard today is a result of my own reflection, to what might have given people some pause. But I think that this country will be the better for passing this legislation, which, as you have highlighted, Senator Nichols, really is a revised and renewed version of legislation that has existed before or has existed in other places.
Just to leave you with this one comment, because the impression might be conveyed that you are the parent of this legislation, but you are actually the person who piloted the bill. And what you say about this bill, whether in here or in Parliament, will not in any way affect how a court interprets the legislation. And you don't let anybody to interrupt you, you know. You should have some manners.
Honorable members,
You should have some
honorable
manners.
members.
You know, wake up, right? Right.
Honorable Leader of the
back to
Opposition,
sleep.
please. Honorable Senator Nichols,
yes.
please proceed.
Thank you, Chair.
You're making a speech.
He's no waking up, right? Huh? Yeah,
Senator Nichols, proceed
Huh?
to ask the question.
I don't gossip, Ralph.
Senator Nichols, Senator Nichols,
Yeah.
proceed to ask what you
Yeah.
are asking.
So, right. So, I just wanted to be very clear for yourself and for the public who is watching that whatever you say is not going to be a basis on which the court interprets the meaning of the legislation.
Well, how is this relevant to anything?
When
How is the court's interpretation?
Honorable Leader
law
of the
hasn't been
Opposition, Honorable Leader.
Why must we sit here and conjecture on what a court will say or will
you
not
can
say?
get as much upset as you want.
Honorable
This
members.
is irrelevant. I was stopped.
No,
I'm
but,
asking
but,
questions,
Honorable
and nobody's making
Leader.
a speech about what a court will say.
Honorable
What does this
Leader of
have
the
to do with
Opposition, you
presidential
had a lot of length. In fact, you yourself said that you were making speeches.
I did not say that.
So,
He made
Honorable
several speeches.
Senator,
I'm
please
responding.
proceed.
Thank you, Chair, because
I'm hearing now
I'm
what a court will
I'm
decide.
proceeding
Why
to
you burdening the lady?
something that he has
Where are you
put to her.
burdening the lady with what a
Right?
court will decide and what the CCJ will ask and all kinds of
I didn't say
nonsense?
anything about any
Honorable, we're out of order. Honorable Senator,
you.
please ask the
CCJ. Sir,
question.
you cannot help.
It's a speech.
No, but don't mind
Right.
the Honorable Leader of the Opposition. Ask
I'm
your
accustomed to
question
it. I'm accustomed to it.
Honorable
Yeah, thank you.
Senator,
So
ask the
that-
question to the
Next with you.
Minister.
So that when we hear about what the court will interpret as the honorable leader
What
of
does
the
the
opposition
court-
has said
what
in
does the
here,
court
the
have to
honorable
do with
leader of the opposition
legislation
has
when it comes to
indicated.
legislation?
Honorable
A court-
Leader of
what
the
the court will
Opposition,
interpret
you're
has
out
nothing
of
to do
order.
with what-
Senator
with
Nichols,
what is
just
before this
ask the
body.
question, please.
This is
I'm
the
glad
legislation that has come before this
I'm glad the
committee.
public is watching, because see
Yeah.
what happens, right? When you're the only person in a place that has any sense, everybody will believe you. But no, he's getting a little fight back on his
But
views.
you were talking about
Thank you.
courts,
That's
you
fine.
made the
Yes.
point.
That's fine.
that
Chair,
the court will
the honorable leader of the opposition,
asking questions.
the leader of the opposition has
Don't
suggested.
mind the leader of the
No,
opposition.
I'm not
Don't
minding
mind
him.
it.
I'm
You
speaking.
have to say about what a
I'm
court will
speaking,
interpret.
right? The honorable leader of the opposition suggested to the minister that because she was a parent of the bill, what she had in fact said in here goes on the record that the courts will interpret. I'm responding to that comment. He does not like what I have to say, but I have the right to say it. And I also believe the public have the right not to be misled by senior members of the bar who know better, right? So that any interpretation of this bill, when it is passed, the first thing the courts will do will look at the language of the bill. The courts will adopt what we popularly call a purposive interpretation.
But how is this relevant, with all due respect, how is this relevant
So-
to the minister's purpose?
Honorable Leader of the Opposition, you had your
How is this
turn.
relevant to this minister's purpose here this evening? What the courts may
No,
or may
but
not
hold
do.
on.
That's
Honorable
irrelevant to
Leader of the
exercise.
Opposition, you had your
Ask the
turn.
minister about the content of the legislation and let's get on.
The honorable leader of the opposition misled the public when he suggested that the minister, because she was the parent of the bill,
That's what she
the
said.
answers to his questions in here would be the basis upon which the court would interpret the legislation.
What's the point?
I made my notes then, and I'm making the point that this committee should not accept that because that is nonsense on stilts. That the court will interpret the minister's answers to his questions as the basis of how the
So why
legislation
put
should
that
be
to the minister?
interpreted.
Why are you
So
putting that to the minister? Argue that
All
with
right,
me.
okay.
Argue
Honorable
that with me.
members, we are
Put
going
that
to
to the
settle
minister.
in here now.
So
So, Honorable Senator, you have made your point,
Yeah.
and you are correct, in my opinion. Is there another point?
no, Chair. I just wanted to make that clear for the record
Yeah,
because I
you
didn't want the
made it
minister
clear.
or the public to go away with the impression. Yeah.
I don't think that the reasonable public would have taken what the opposition leader said. The honorable public knows.
You say.
Do you have
you say that
any other?
expression and speech are two different things.
He feel like Steve, like he can shout at me.
And Nichols disagreed with you.
Senator Nichols, you're finished?
You remember?
I am true, I'm true,
So,
Chair.
honorable members, please. I know it's been a long day.
Agree with the chair?
No, honorable members, this will stop now. Senator Nichols, Member of Parliament, please. I just wanted to say a few things to draw your attention to a few sections, Honorable Minister. The first thing is that the Budapest, honorable members, come on. Y'all are members of the legislature. We have to set a better example. Come on, there's no cross talking here now. No. Good. Well, we stop. The Budapest Convention, of course, is a European convention. Barbados is not a member of the European Union or the Council of Europe. And therefore, it is not, for example, a situation like a UN convention where Barbados is a member of the United Nations. And the Council of Europe has said that any person who wants to sign on to the Budapest Convention must pass cybercrime legislation before signing on. So the point that the Honorable Leader of the Opposition was trying to make as
I
to-
was not trying to make a point.
No,
I was
no.
asking questions.
Well, the
for sake
issue
of the
that,
public,
no, the issue that you raised.
So that the public will hear.
Right,
Why
and
the legislation was passed, the
Right.
origin of the
And I
legislation.
now
the
explain
content
it.
of the legislation. I did not make a speech.
Right, I'm now explaining
To who, the public?
that Barbados is not a member of the Council of Europe, so it's
But
not
the
a
minister
case
say that,
where.
Chairman.
No, but the other reason is that it is not a case where Barbados would sign on to that and then pass the
I
legislation.
did not assert anything. I asked the minister questions.
Yeah,
She
but
gave
what
answers.
you're concerned about, I'm giving a further explanation.
No, I asked the minister. She gave the best explanation.
Yeah, but I
And it
know,
was clear.
I am now not talking about what the minister responded
Well,
to
you're
you.
adding
I'm
to it.
adding to it,
But the
exactly.
minister gave the best answer.
The second issue is that the Computer Misuse Act has had criminal penalties for almost 2 decades. So this is not the first time that issues relating to malicious communication, for example, will be subject to criminal penalties. The Act isn't bringing anything new in that respect. It's expanding on the Computer Misuse Act, which has been part of the law of Barbados for almost 2 decades. The third thing is that we focused on Guyana. Guyana's legislation is 2018. Jamaica's was before that. Jamaica had similar cybercrime legislation since 2015. And Jamaica is not polarized by the racial divisions that the honorable leader of the opposition was seeking to portray is the case in Guyana.
Mr. Chairman, I am not seeking to portray anything. I was asking questions.
Yeah, we understand, and
So
I'm helping to give
to
clarification here.
pursue whether there's any change needed to be made to the legislation, and the honorable minister came here today and suggested that there are changes that need to be made. Please record what the honorable minister said.
Yes, we're. But I'm putting on record that Jamaica as well has similar legislation even before Guyana. And Jamaica, I don't think anyone would wish to suggest is polarized by those racial
Mr. Chair, is this part of your duty?
Yes, but...
It is?
Yes.
If it is, I'll keep quiet.
Okay.
But the minister came
I
and gave
hope
the
so,
evidence.
because you had your chance for a long time. So, Honorable Minister, I'm going to just ask you to look at some sections of the bill as drafted. Section 8, illegal interception of data, where the fine is 100,000, maximum fine, as we have indicated over and over, imprisonment 10 years or both. And just wondering if you, on reflection, as you said you've done, and I thank you for, the amendments you've come here and proposed today. If on reflection you would think that this is a bit harsh, Sir David felt it was, and maybe that those could be adjusted, as the others are, the 70,000 imprisonment to 7 years.
Okay, just so that those listening are clear on what we're talking about. Illegal interception of data, a person who intentionally and without authority undertakes an act to intercept by technical means any non-public transmission to, from, or within a computer system, including electromagnetic emissions. I want us to understand what this is, why the penalty is higher. Including electromagnetic emissions, so you haven't even gained access to the computer system. You are within sufficient distance to pick up emissions from a piece of equipment or a system. Including electromagnetic emissions from a computer system carrying computer data is guilty of an offense and is liable on conviction of indictment to a fine of 100,000 or imprisonment for a term of 10 years or to both. Why does this carry a higher penalty? Senator Nichols quoted earlier some figures with respect to the economic loss that we have seen and that we can expect from cybercrime. In this field, interception of data and intercepting non-public data is one of those acts where we have seen the highest damage and loss. So we are talking about the act of you go on a website to put in the password for your bank. Somebody intercepts that information. That's meant to be a non-public transmission. Somebody gains access to your entire bank account, to your company's bank account, and is able to steal resources, is able to disable a company, is able to, it is in many jurisdictions, the penalty is even higher because of the scale of theft that it allows for. Electromagnetic emissions, so imagine, and this kind of act is often also used with respect to terrorism. You are somewhere else in the world, or you are not even near the computer system, and you have a device that allows you to pick up emissions from a computer system and use those to commit a crime. I explain that because I want us to understand that this is not just a question of looking at a number and saying that's too high. There is a reason that there are higher fines associated with certain provisions in this legislation. If it is the judgment of the committee that, or if it is the recommendation of the committee, not the judgment, that a lower fine could be suggested, that is within your purview to do. But I'm cautioning you that it has to be indexed to, or it has to be with reference to the other offenses or the other fines in terms of imprisonment, because it is considered a far more, potentially a far more damaging act. And so I would offer that as my response.
Thank you for that explanation. Section 11, disclosure of access code. Section 11(1) and 2 seem to be quite similar, and I was wondering if you would wish to agree that one of them could be removed. And let me read. Subset 1, a person who intentionally or recklessly and without authority discloses any password, access code, any other means of gaining access to any program or data held in a computer system, guilty of an offense. And 25,000, 3 years. Subsect 2, a person who intentionally or recklessly and without authority discloses any password, access code, or any other means of gaining access to any program or data held in a computer system for an unlawful gain. This adds for an unlawful gain, whether to himself or another person, and knowing that it is likely to cause unlawful damage. It's guilty of the offense, and there's 70,000 or 7 years. I know the subsect 2 adds on the unlawful gain aspect, and knowing that it is likely to cause unlawful damage. So it's the
I was going to tell you,
justified.
Mr. Chairman, that you accuse me of not being a lawyer, and you caution members not to address me as they would a legislator, but it seems to me that I'm able to pick up the finer points of these two clauses a little bit better. Let me go further. As you've highlighted, at 11(2), it makes the point about unlawful gain. And again, similar to the earlier clause that I explained, the distinction being made here is the intent. So at 1, a person who intentionally or recklessly and without authority discloses any password, access code, or any other means of gaining access to any program or data held in a computer system is guilty. So at 1, the intention, a person who intentionally or recklessly and without authority, those things in themselves, you disclose a password, an access code, or a means of gaining access, you've done so intentionally or recklessly and without authority. May not be for any particular purpose, but you've done so. That carries a lower fine or term of imprisonment. At 2, the unlawful gain, the intent to defraud, the intent to steal, the intent to pass those resources on across borders for all kinds of reasons, to fund certain kinds of activity, that is what imputes, or that is what attaches the higher penalty. So I would not agree that they are that they repeat themselves. I think that the distinction is being made. At 1, there's intent to pass on the code that you know you don't have authority to pass on. At 2, there's intent to pass on the code, and there's further intent for unlawful gain, like such as, again, I described having access to a bank account, or being able to impersonate a person who is able to authorize certain financial transactions. I think that burden, that level of criminality goes a bit higher, and that's why the two are separated. Again, if you have recommendations for the level of fines, I'm sure that's something that could be considered.
Thank you for that. I'm just giving you the opportunity to respond to some of the criticisms and points that were made earlier. In terms of corporations, this bill as drafted only seeks to penalize corporations under Section 17, child grooming, Section 16, I think it is, the child pornography, and Section 18, sexual abuse. While other legislation, certainly Guyana's and Jamaica's, certainly Jamaica's, brings corporations under its penal provisions through penalizing the director, manager, secretary, or similar company officer. And, was wondering why perhaps corporations weren't penalized or subject to penalty throughout the act, but only for those three provisions. Is there any specific reason?
So your suggestion is that corporations should be subject to criminal penalty for what kinds of offenses?
Or cyberbullying, for instance. Cyber terrorism.
So you are suggesting that a person who is employed by a corporation who engages in these activities should cause the corporation to also face criminal prosecution?
Yeah, and acting within the scope of their employment as agent for the corporation.
Acting as an agent for the corporation would mean, proving that they're acting as an agent for the corporation is an interesting one. But acting as an agent for the corporation would mean that the corporation should also face penalty. I do not like to respond to matters of policy and law on the fly, but I would suggest to you, I have no objection to, obviously, to considering a recommendation of this committee that frames that, and we'll see how it lines up with the rest of the bill.
Thanks for that response. Section 19, the intimidation, and we all recognize that this is one of the, most controversial sections. The intimidates, and you also referred to the, question of intimidation. And the definition, well, you said you would have put it a different place, the definition of it. But under Section 19.4, intimidate also can mean causing a person substantial emotional distress. And the question arose as to whether that aspect of intimidation, the definition of intimidation, should also be ring-fenced by the Defamation Act defenses.
So you are suggesting what language, Chair?
That the same way how 19.3 is covered by the defamation defenses, shouldn't consideration be given to causing a person substantial emotional distress be ring-fenced by the defamation defenses as well?
So you're saying that what is covered at 3, the defenses should obtain equally for 3 and for 4?
Well, no, not all 4, because to intimidate by telling someone you're going to injure them or the family, or do violence to them or damage to their property or to themselves, I can't see how defamation defense
Right, that's what I
could be
was going to
applicable
suggest.
there.
Right,
But for the third limb, for A3, causing a person substantial emotional distress, whether that could fall in the same category.
I don't quite agree, perhaps this is a finer point of language, but I think that the defenses of truth and so on, I don't really see how they apply. Remember that 3 is a subsection of A, intimidate. So it is a part of the definition of intimidate. And so to the extent that you're not just talking about, so at 3, a personal intention use or can produce a system to disseminate image or words, not caring whether they are false and likely to cause, I think we had said embarrassment is guilty of an offense. I would say to you, Chair, that these definitions are very different. I'm not sure that definition obtains at 4. Because intimidation is defined as it's defined. So
But there are, it isn't all one. It is the apprehension of violence or injury or substantial emotional distress.
I
So I
understand.
was just wondering if you could take out the substantial emotional distress
Oh,
and put it in 3, so it is covered by if what you're saying is truth, for example, or trivial, that there would be that defense.
again, if the committee wishes to suggest a particular amendment that you think causes makes the legislation stronger or more clear, it's something that we would consider. In my mind, the definition of intimidation is so separate from what is meant, from the defenses, from what the defenses are meant to apply to at 3, that I saw them as separate. But again, I mean, I'm not going to sit here and accept or deny a recommendation unless it is completely at odds with the intent of the legislation. So I invite the committee to make its recommendation.
Okay. And last one, Minister, as you're aware, of course, some people have criticized Section 23 going forward, and the issue of a search warrant by a judicial officer. And of course, I think we agreed that Section 23(1), where it says the magistrate may issue a warrant, should also say, you know, the judge or magistrate. But the question has arisen as to which police officer, because Section 23 speaks towards any police officer being able to go on oath and apply for a search warrant from a judicial officer. Whereas later on, for example, Section 28 speaks towards, well, Commissioner of Police or any other gazetted officer. Section 27, the judge or magistrate being satisfied on an ex parte application by commissioner or other gazetted officer. And was just wondering if, similar to Guyana has it that the officer has to be at superintendent level or above to be able to go and apply for a search warrant from a judicial officer on oath. And I am just wondering whether you would be amenable, and of course you can't bind yourself, I'm just addressing your mind to it, whether Section 23 should limit it to gazetted police officers.
What's the mischief that you consider there, Chair?
Well, that the officers should have some senior rank to be able to go and apply on oath to the judicial officer to get a search warrant. I think the concern, as I read it from some Barbadians, is that, you know, any police officer, and some police officers may just do it on, you know, because they don't like you, because you do them something. And I was just wondering if it may perhaps be better to limit that to more senior police officers.
I would say that I would be willing to be guided by what obtains for other kinds of warrants. Remember that this is not, a computer is not a magical thing. It is just a domain in which the activity of certain procedure is taking place. So I would be guided, and we should all be guided, by what obtains for search and seizure in other areas of legislation. I am not wedded in any particular way to this particular provision, but I would encourage us to be guided by that. What I will say is that when it comes to preservation of data, and warrants regarding the preservation of data, that we should not increase the level of authority, because as I mentioned to the committee earlier, preservation of data, a warrant for the preservation of data is really just to be able to stop the data from being destroyed. And in many other jurisdictions, it doesn't even require judicial intervention. It doesn't require law enforcement intervention. We maintained that because of our social need and circumstances. But we do have a trade-off in the sense that it in a way could defeat the purpose of preserving the data. If there's too high a level of authority such that it takes too long, remember, it's just preserving. You're not harming anything, you're not changing anything. It's just to stop it from being destroyed in the hands of a third party. So it's not in the hands of government, maybe in the hands of a telecommunications provider and so on, that we not increase the burden there. We already have it. Our legislation is actually perhaps the only one that requires a warrant for data preservation. But that we should preserve it, not to use the word in two contexts, but we should keep the level of authority for data preservation where it is. But if you want to recommend a change in keeping with search and seizure in other legislation, there's no need to have special provisions here. This is just, computer is just a domain, no different from a house or a public place. So that would be my only guidance.
Thank you for that response and for your responses. Minister, we thank you for coming this afternoon to, you know, expand on your thoughts as Minister, you know, responsible for this bill, responsible for presenting it. We appreciate, you know, that you, on reflection, are proposing yourself some amendments to it. And, you know, we have now closed off the oral hearings on this. We have the written submissions, and we clearly will, you know, set some timelines and when we could reflect on it and get a report back to Parliament. Okay?
Thank you. Just in the final 2 minutes to say, well, this has been a very rambunctious proceeding, far more so than I expected it to be. But just to give my thanks, truly, to the members of this committee. I perceive that you are passionately defending your various positions and that you have brought a certain level of rigor to the analysis. And I also want to say to the people of Barbados that
Members.
I also want to say to the people of
Let's
Barbados
wrap up.
that I feel quite privileged that this legislation has enjoyed the level of engagement, has attracted the input and the discussion. I do not consider that what has transpired with respect to the cybercrime legislation is at odds with the democratic spirit of this country. I think it is very much aligned. In fact, I have a sense of pride in the extent to which Barbadians are willing to consider the policies and legislation that affects them and to have and to attempt to have an informed position. And I focus on informed because I think it is important that we not encourage misunderstanding willfully, and that we instead guide our various spheres of influence towards honest debate. In that regard, I consider that some of the feedback has been useful, some of the concerns have been genuine, and I am therefore grateful to have had the opportunity to reflect on those with the members of this committee, and I feel confident that we will emerge with effective and useful legislation to deal with these matters. So I thank you.
Minister, as you know, I said at the beginning here this afternoon, the Senate is going to have to deliberate on an expansion of our mandate. Let me ask you this question: what kind of time frame are you looking at in terms of a report?
You know, to the extent that these matters are national security matters, a lot of what is represented in this legislation is really the subject of a national security conversation. I'm always hesitant to say too much in that regard. Suffice it to say that what has motivated us to pass this legislation is upon us. What has motivated us to pass this legislation is upon us. The risks that exist are near and present. And in the region, we are aware of certain exigencies. So I would say that the timeline is now. I would wish to prevail upon you, Chair, and the committee to allow us to have a report that would mean we can advance this legislation as soon as possible. We have events coming up that mean that we will have the world at our shores. And I really urge us to proceed with dispatch. This is for matters of safety and security. We have to have a maturity of political cooperation. That means that we unite to protect this country and our citizens. And so I would encourage you to move with as much haste as possible. I think I've said enough for you to get my meaning.
Okay, thank you. Members will go on to any other business when Minister leaves.